Okay, so what's probably going to happen, I'm not sure. This is the first time I've been in front of this judge, and it's my mistake, and these things should not happen, but I would have missed the 3-day window to give her a hard copy. So what I'm going to do in this proceeding is give her was ask the court for a continuance so that I can get the hard copies to the judge of this file, which is some 85 pages. So if she grants a continuance, then we'll just pick up on another date. If she doesn't grant the continuance and just wants to go ahead and proceed now, I'll go ahead and proceed and make the argument that the hearing officer's recommendation is no good because it's a fraud on the court, because the hearing officer, in the case where you all could see, it's the how to deal with the Title 40 hearing officer, mentioned some $56,000. Anybody who watched the video knows the only amount that we discussed was, in fact, $830 some dollars, which even I didn't agree with that. But we'll see how this goes today. There's a few minutes before she comes on, and we'll kind of take care of it. And I'll tell you right, because I'm in a courtroom today or in front of a judicial officer versus an administrative hearing officer, I always wear suits when I go to court. It's not to give off any other look, but it's just so that for the fact that I can look a lot more presentable and professional in doing so. So we have a couple of minutes and we'll get to it and see how this goes. Aside from that, because I have been a little more active on my YouTube page, if anybody has a topic or a case that you may want me to delve into, please feel free to reach out to me either via YouTube, or you can always go to my website, gdnapsc.com, and we can, you can access my email through that, which is actually gdnapsc@gmail.com. And I'll be more than happy to spend a few minutes reading cases. I'm not really into this for the money. Of course, I do have services that I offer, but I have other things going on, such as case 22-CV129 in the Middle District of Florida Federal Court, which is what I have said on one of my other videos, I believe, or I put it in the inbox, that I believe a lot of stuff came back because I successfully defended against a improper prosecution where a judge and the mayor's bodyguard falsely accused me of perjury. I won that case self-represented, and I'm now suing in the Middle District for malicious prosecution. So I think that a lot of this other stuff is more retaliation because it's not substantively based. We all can see that just by virtue of what came out of that last hearing. So it's due to start at 1:30. I'm going to go ahead on and focus on whatever may come from in front of me. And either way, let's see how this goes. And actually, I believe this is actually the first time I've ever been. Well, no, it's not. I think I've had two other instances in front of an actual judge. They tend to push me around and try to pass me around to these hearing officers, and we all kind of have an idea how that tends to go when I'm dealing with a hearing officer. And really, all I want them to do is just follow the law. And I'll show maybe on one of these videos coming up, I've probably filed 8 or 9 appeals total. I don't know how many for myself. And I've never had a written opinion. I've always had PCAs, which in Florida is called a per curiam affirming, meaning they don't give you a ruling. They simply make a affirming of the lower court. They do that in Florida, and what that can do in Florida is it can cut off your access to the Supreme Court to review even an improper ruling by a district court of appeals, and you have to do certiorari. And once you do all that, then everybody probably knows that you have to then go to the United States Supreme Court, depending what your issue is. And again, nothing I say on any of these videos should be construed to be legal advice. So hey, it's about that time. So let me go ahead and hit this board, and you all can follow along as I get ready for Judge Oster. If anybody can hear me with Judge Oster, the JA, I'm Shagret Doss in the case of Department of Revenue versus Doss, and I am ready to move forward.
Hello?
Hey, good afternoon, Miss Scott. I don't know if the judge sees you all, if you all can see me, but I am in the breakout room, waiting to be seen.
Okay, no, I can't see you. They hasn't even let us in yet.
Oh, okay. Well, we may have to reschedule this, and it would be my fault, but I was out of town because of my aunt, and I didn't look at the rule because the judge needed a hard copy. I would have just sent one to one of my boys and told him to walk it over. I'm going to ask for a continuance if she doesn't want to hear the case. I'll just ask for a
Okay.
continuance and I'll reset that. So it shouldn't be that big of a deal. But we'll see how it goes. I'm here. I just want to let you know that I'm here and waiting. So if she says she doesn't see me, tell them Mr. Doss is waiting and they can always contact. Oh, we're coming in now. So I guess they see us.
Okay, all right, cool.
All right. Bye. Good. Good
Judge
afternoon,
Oster, can you hear me?
Doss.
Hello, sir. What is your name?
I'm Shagret Doss. How you doing, Judge Oscar?
Okay, I'm doing well, sir. Okay, so we have Mr. Doss, and then who's Hulda Comrie? Are you with the department?
Yes, the Attorney General's office. Yes, ma'am.
All right. And folks, according to my notes, we're set today on respondent's motion to vacate an order that actually I believe was signed by Judge Smith on a hearing officer's recommendations as it relates to a child support matter. Is that correct?
Yes, Your Honor. And I apologize. I probably should have just sent it to somebody else. I'm so used to this is like one of the few times I've actually had a judge. I didn't realize that your rules required that I give you a hard copy. I did submit a copy via the email. And if it's going to be an issue, I guess we could just take care of it earlier right now and reset this for later on, and I can get it to you.
Oh, okay.
My aunt, she
Right.
passed, so I'll be leaving again I'll be out of town until Monday, to deal with her funeral.
Okay. So yes, I need it in hard copy, sir, so it can be properly filed with the clerk's office as we go through the hearing. So do you want a reset maybe to have an opportunity to provide the hard copy?
Yes, Your Honor, because I did provide the hard copies so I file everything electronically, but I understand your rules better, and that was on me because I didn't actually know you were going to be the judge. So we can reset this, and since Mrs. Carmy is here,
I'm not agreeing to a reset.
huh? We
Sorry, ma'am, what's that?
I said, I don't agree with the reset. You could have looked on her page and found out what the rules were.
Well, then we can
All
do
right.
we can do it now. It doesn't matter. I can go for it. The court would probably benefit from having it, but if not, that's fine with me, Miss Carmy, because the facts
Well,
don't change.
what I would have to do if the documents were admitted, sir, is I do need a hard copy to have filed with the clerk to perfect the record. So, I mean, I guess I can give you an opportunity to do that after today's hearing.
No,
Um,
they are in the record, Your Honor. I filed them all electronically. If you look inside the clerk's docket, with the exception of the 85 pages, which I did provide to your JA, everything else is in there.
yes, that's the part that's missing. There's something you submitted by email or by email today at 12:30 or something like that I don't have a hard copy of. So if
Okay.
those documents would have to be provided via hard copy.
Well,
All right. Well, let's just see where we go from here. Miss Comrie is objecting to the continuance, but I may give you time to file those supplemental materials where a hard copy is provided so we can properly get it filed with the clerk.
eh,
Okay. So let me see here. I want to make sure though that Miss Comrie got a copy of those. Miss Comrie, did you get a copy of the supplemental materials, ma'am?
Yeah, last minute copy.
Okay. All right. All righty. So the moving party is the party that goes first in these proceedings, and then I give the responding party, which would be Ms. Comrie, an opportunity to respond. Please keep in mind, folks, that this hearing is only set for half an hour, so if we can't accomplish what needs to be accomplished in that amount of time, we'll have to have a continued hearing set at a later date and time. So what that means essentially is that Mr. Doss, you have 15 minutes and Ms. Comrie has 15 minutes to provide a response. Okay, sir, you ready to proceed on your motion?
Yes, I am, Your Honor. It's really simple. My motion was a motion to vacate hearing officer Arabella Campbell's denial of my motion to contest the suspension of the driver's license. But we could get into the underlying issue, which is that there was neither me or the mother at the time that the original order was set were even at the hearing. So that would be a procedural error because this is not an administrative case, this is a judicial case. But the mother subsequently in 2013 filed within the record a affidavit stating that she wanted nothing else to do with this case. This case has been closed for some 8 or 9 years. After I filed my action in the Middle District, which was related to one of your former, I don't know if he's your former colleague, I don't know if you've been around that long, Judge Holder and the mayor's bodyguard, Michael Victor, falsely accused me of a crime of perjury. I won that case successfully after disqualifying 4 of the 13 Judicial Circuit's judges, and then the Florida Supreme Court's chief judge at the time, Justice Lombarga, sent a visiting judge in to hear the case. The case was ended in my favor. I won the case. So part of it, I believe, was a retaliation. But beyond that, the issue for the court today in my motion is I moved to set it aside, the vacater order, because hearing officer Arabella Campbell misled the court and intentionally misled the court when she gave her recommendation, because she stated in her recommendation that we discussed some $56,000. Now, what was done in plenty of time for the court to have a record of it is I did submit a copy of transcripts from the hearing in, I think it was March 24th, that I submitted those transcripts. So the court should have a copy of that. The findings were stamped on April 1st. And if you look at my exhibit B, I guess she doesn't have it, but they would have a copy of the order denying my motion for me to contest the suspension of the license.
Okay, and that's attached to your motion. Are the exhibits you're referring to now, sir, attached to your motion?
The exhibit, well, one is filed, an inclusion of transcripts was filed on June 18th. And the transcripts will tell the story as to what happened. And it is, if you don't have a copy of it, it would be exhibit C. And in the transcript, I did the court, or I did myself a favor actually, but the court would see that in the inclusion of transcripts, I highlighted some important areas, and nowhere in that transcript, in a simple control F, the court will see we never discussed $56,000. More importantly, hearing officer Campbell, against my objections, by the way, disregarded the fact that the mother not only filed the affidavit, but that the mandatory disclosure rules were totally ignored by everybody. There's no testimony in the record. And this would happen before I became, as I'll guess, say, savvy with court proceedings and court posture. I didn't even pay attention to that. So the case is the original order that was submitted back in 2004 is just no good. There's no attachment.
Okay, and that's because there is no mandatory disclosure in financial affidavits, things of that nature.
Yes, Your Honor. And also at the time, the rule was that the final order had to have a child support guidelines worksheet attached to the final order, which is not the case. And I did file certified copies of that in the record. And Mrs. Comrie is aware of this as well, but that is fine. The other issue is because neither myself nor Miss Ball or Morgan at the time were there was no testimony. Nobody was there to provide testimony. In the face of the final order states who was there. And you can go back to, let's see, if you go to D, well, I guess you don't have it. Let's do this. Let me go into the actual clerk docket. And I think we can follow it a little bit easier that way. I'll sign in. And if Mrs. Comrie, which I don't understand why we're doing this now, because she's more than aware of how this case is. She knows that the original child support guidelines worksheet, and you can look that up, Your Honor, is not attached to the original order from October 2004. There was one that was filed earlier, but nobody testified or swore to it. So it's an unsworn document at minimum. And because it's an unsworn document, we know I can provide substantial case law. The unsworn document is no good either. I think we're kind of splitting hairs with this. The bottom line is, as it relates to my motion to vacate or order, it's because of a fraud on the court. An officer of the court intentionally, and despite her obligation of candor to the court, submitted a recommendation to Judge Smith, who, instead of following or going back and reviewing the files or the transcripts, rubber stamped her recommendation. And had he done, and that we know Gregory versus Rice would cover that part. He just rubber stamped it. I don't know. Him trusting her is not my issue. My issue is she intentionally misled the court. She disregarded her duty of candor. And I'm not an attorney. I don't pretend to be one, but this is an issue that I would hope the court would sponte recommend to the bar for discipline, because the DOR operated on that improper recommendation and suspended a license. And they suspended the license when it should have been told, because I filed my motion to vacate timely.
Okay, so let me make sure I understand your argument, sir. You're saying that at the time that the final judgment was entered in October, was it 7th of, October 7th of 2004, it was erroneously entered because there was no mandatory disclosure that had been complied with, and there were no child support guidelines attached to the final judgment. And you're saying there was no person present, I guess you or
neither Ms. Ball or Morgan at the time
were present to provide testimony.
Right.
And so the original final judgment should not have been entered. Is that your argument, sir?
Yes, Your Honor. And we can cite the Durham case of 850 SO2D 653, 654 out of the second DCA in 2003, where it's a reversible error for the court to fail to include a child support guidelines worksheet in the final judgment establishing paternity. And because the guidelines worksheet with the judgment is mandatory, this court, or it says at the time, is required to reverse the judgment, even if the omission is due to the party's failure to comply with the rule. But mandatory disclosure is mandatory disclosure.
Okay. All righty, sir. Anything else for you? I want to save you a few minutes for a rebuttal.
No, thank you, Your Honor. I was going to ask for 5 minutes. Thank you.
Okay, so I guess not. All right, Miss Comrie, what's your response, ma'am?
The department's position is that the court can't grant relief that Mr. Doss is seeking. You cannot use the driver's license contest to then try to argue the issue of the underlying order is invalid. The hearing was scheduled for a driver's license contest. That's what the issue should have been presented at that hearing. According to the rules, 12.540, the time period to argue that the underlying order was invalid would have been within a year. Mr. Doss never attempted to argue that or file any motions regarding that. He did try in September of 2013 to state that the order was void, and I think it was hearing officer Coffey found that his motion, he denied it based on the fact that he didn't have, he denied it based on the fact that, I can't think of the word, he dismissed it basically, saying it didn't have any ground.
Objection to that.
So then he again tried to argue that the issue in November of 2013 in front of, I think it's hearing officer Stello, he wanted to get the action dismissed because he was complaining then at that point, the argument was if there was an error. That again was denied. So as far as the department's position is, it's been more than a year. This order is now almost 20 years old. The court has no jurisdiction to even try to set aside the final judgment. The rules allow for a year. It wasn't argued within a year. He's correct. Nobody was present at the hearing. However, financial affidavits were submitted to the court.
Objection.
And the rules actually require that either the guidelines are submitted beforehand or at the time of the hearing. The guidelines were submitted, I believe, around August of '04, and then the final judgment was entered in October of '04. So his argument about attachment, I don't know if he's upset that they weren't scanned at the same time. They have two different docket numbers. If you look on the clerk's page in his court file. So the guidelines were submitted. They were submitted prior to the final judgment being entered. So the department's position is that the court doesn't have jurisdiction to set aside that underlining order. It's been found to be valid by two other judges previously on various issues that he's tried to argue. And this was all set for a driver's license contest. So trying to vacate the driver's license by then arguing the underlining order when your time frame has already lapsed, the court can't grant his motion to vacate. And that's the department's position.
I would object to a couple.
Well, yeah, hold on, sir. I'm going to give you an opportunity to respond. Okay, so Ms. Conrad, I just want to understand what your argument is. So you're saying that this court can't grant the relief requested because the vehicle being used is to challenge a driver's license contest rather than, I guess, an original motion to vacate the final judgment that should have been filed within 1 year after the final judgment was entered. Is that the argument you're making?
That is correct.
Okay, and then as to the guidelines issue, I believe you're saying that the guidelines need to be filed either before or simultaneously with the final judgment that was issued, and they were filed, I think previously maybe 2 months before the final judgment was entered, as opposed to simultaneously. Okay.
Yes.
Okay. All right. Anything else for you, Ms. Comrie?
No, ma'am.
All right. And so, Mr. Dawes, I'm going to give you an opportunity to provide a rebuttal to what was argued by Ms. Comrie.
Okay, so to the issue of the non-challenge of jurisdiction, I did, because the court would be without jurisdiction without parties for it. Ms. Comrie, I think, again, just misrepresented facts of the court. I did file a motion to challenge the jurisdiction, and Mr. Coffey had the deputies walk me out of the building. It was never addressed. There's no order ever addressing that. And it can go under newly discovered evidence as well. But let's go down there. It's still an intrinsic fraud. And I'll have the court rely on unsworn statements by attorneys cannot be used as a basis to make a determination. And I'll cite the case for you. You can go into the cases Blimpie Cap Venture versus Palms Plaza, and that's 636 SO2D 838, and it's 1994. And the court is clear when it says we have held that in the absence of a stipulation, which we know even for mandatory disclosure, you still can't move. A trial court cannot make a factual determination based upon an attorney's unsworn statement. Furthermore, and that's actually out of State versus Bergen, and that's 588 SO2D 279 out of the Second District Court of Appeals, in fact. Now, a trial court, as well as this court at the time, is also precluded from considering as fact unproven statements documented only by an attorney. And that's Schneider versus Curry, 584 SO2D 86. And they say also, if the advocate wishes to establish a fact, he or she, in this case, must provide sworn testimony through witnesses other than himself or herself, or a stipulation to which his opponent agrees. This is
okay. So let me stop you there, sir. I just want to make sure I understand what you're saying. So, are you talking about any testimony in support of the original final judgment?
Yes, Your Honor.
Okay. And you're saying that was made by attorneys only, and you're saying that's not sufficient factual evidence.
The courts have never called that sufficient factual evidence.
Okay. All right.
I cited the case law.
Okay. Do you want to make a couple of additional comments?
Well, yes, Your Honor, because if the issue is, it's still a due process issue, and because the attorneys move forward, I could argue it's fraud, and then the fraud makes the judgment void, whether it's intrinsic fraud, because it was intentionally done. And
you're not saying it's a mistake or something like that.
No, it's intentional. Misrepresentation and misconduct by the Department of Revenue. I believe that was Minish and McIntosh, and we knew they had a very salty reputation for a lot of unseedy activity. And Ms. Comrie knows that as well. The reality of it is this. It's a procedural issue. I'll make sure I preserve all my objections so I can uh, file my appeal. But the reality is the court never had any jurisdiction on this case because you didn't have the parties necessary to uh, solidify the action. And if it was the state, you didn't have any facts, none. There's no child support guidelines worksheet that I swore to. There's no financial affidavits. The rule is clear. 12.285 is very clear. You can't waive it. Those mandatory disclosures could not be waived. That's the rule. If the court disregards the rule, that is a procedural error. That procedural error makes the order void, not voidable. It's no good. And the other issue I want the court to take real note of is back in 2013, November 20th, Ms. Ball submitted on her own an affidavit, which is in the court's record, that states she wanted no further dealings with the Department of Revenue as it related to this action. She said she wanted no more arrears. She said she wanted nothing. That's Mrs. Ball's testimony. Now, unless Mrs. Comrie is arguing that the affidavit, which reads, I, Cleve Ball, willfully state the following: I am a party in an action with the Florida Department of Revenue / Florida Child Support Enforcement Program, case number 03DR6755 against Shagrette Doss. I hereby discontinue any and all participation and affiliations with the Florida Department of Revenue and or Florida Child Support Enforcement related to Shagrette Doss. I, Cleve Ball, am discontinuing any participation in these actions with prejudice and without any future demands to Shagrette Doss relative to the aforementioned action. I have no desire for arrears or any future compensation. Furthermore, this affidavit of fact may be filed with the 13th Judicial Circuit in Fort Hillsborough County, Florida, without further notice. I make this decision without threat, duress, or coercion. It's signed Cleve Ball Morgan, and it was actually notarized by your clerk of court. I'm not even a part of that. And it was filed, whoever Candace Harris is. And I would just say, if you want to make an argument, we just bring in Candace Harris. But the affidavit will sit for itself. And there's a certified copy of the affidavit in my exhibits.
Okay. All right, sir. So let me ask you, did you want to admit any of your exhibits? And if so, which ones?
Well, the entire supplemental, but definitely Mrs. Ball's affidavit, the final support order, the final judgment for support, which was the one that you read from, where it states clearly that me and Ms. Ball weren't there. The only one there was some attorney from the Department of Revenue. And also, I want the court to take mandatory judicial notice of 12.540 the Florida Family Law Rules of Procedure, which states that there's on motion or such terms that are just, the court may relieve a party or party legal representative from a final judgment, order, or proceeding for the following reasons: mistake, inadvertent, it's not even excusable neglect; newly discovered evidence which would apply, which by due diligence could not have been discovered in time to move for a new trial or hearing; fraud, whether heretofore denominated intrinsic or extrinsic; misrepresentation or other misconduct of an adverse party. That's number 3, that the judgment is void. Or 5, actually, that the judgment has been satisfied, released, or discharged, or a prior judgment on which it is based has been reversed or otherwise vacated, or is no longer equitable, that the judgment should have prospective applications. Now, they say within a reasonable time for 1, 2, and 3, not more than 1 year after judgment, but the other ones don't have a time limit.
Okay, so there's a lot of material, sir, attached to your motion to vacate. Some of it is case law, so that would not be an exhibit, but other items are identified and are probably more properly considered an exhibit. So what is it that you want admitted as a specific exhibit?
The transcript, okay, exhibit A, which is the respondent's motion to contest the driver's license suspension.
Okay, hold on, let me get there. Okay, let me see here. Is that marked as an exhibit, sir?
Yes, Your Honor. In fact, it's going to be exhibits A through E.
Is that in the supplemental material?
Yes, Your Honor, but it's also on my respondent's exhibit list.
Okay, let me take them. So I see exhibit C marked. What, I don't see exhibit A marked in the material. So that would be the motion
To contest the suspension
to
of the driver's
contest.
license.
I don't think that has to necessarily be admitted as an exhibit, sir, because it's the motion that's the subject of discussion. I can do that, but I don't know if it's appropriate for that.
Okay, well, the finding of order denying the relief, because on that order denying relief, Mrs. Ball's or Morgan's affidavit is attached. I think it's very important that because Mrs. Cromney is trying to rely on what happened in that hearing, the inclusion of the transcript goes to the foundation that Miss Arabella Campbell intentionally misrepresented facts to the court as a hearing officer of the court. She's an officer of the court. She misrepresented the facts. The court never produced the documents that Mrs. Campbell is claiming were produced. We didn't discuss that.
Okay, hold on, sir. I just want to make sure I get the exhibits identified and properly submitted.
Yes.
So what I have here in the supplemental materials that you emailed that I'm going to need a hard copy of.
Yes, Your Honor.
Is the motion to contest suspension of driver's license and request for hearing. That's exhibit A.
Yes.
Do you want that admitted?
Yes, Your Honor.
Any objection? Ms. Comrie?
No objection.
Okay, so exhibit A will be admitted. Exhibit B are the findings and order denying respondent's motion with affidavit filed on November 17th. Any objection to that?
No objection.
Okay, exhibit B will be admitted. Exhibit C, respondent's notice of inclusion of transcripts in the transcripts. It looks like
From March 26th.
Oh, it says March 21st. I want to make sure I have the right one, sir.
Well, it was filed on June 18th. I think that may be a Scrivener's error, but it's the inclusion of transcripts. The transcripts themselves are what I want to be in there, and that actually was filed within the court on June 18th. So I can correct the Scrivener's error.
Oh, okay. Any objection, Ms. Comrie, to the notice of inclusion of the transcripts in the transcripts? Okay, exhibit C will be admitted. D looks like a certified clerk's docket of this case. Any objection to that?
And that date is March 4th, I believe. It should be first, but I'll fix that. All right.
Oh, okay. So then exhibit D will be admitted. And then exhibit E is a certified final judgment of paternity and support.
Yes, Your Honor.
Entered back in 2004. Any objection? I think you said no, ma'am, right?
No, ma'am.
Okay, exhibit E will be admitted. And then it looks like the additional notes here or documents that are noted as exhibits are actually case law.
Well, supplemental authority to support the cases used, which I was going to use inside this as well, but they're also supplementing reference case law from other filings.
Okay. So that's really part of the argument and not really an exhibit, sir, but certainly something I can take into consideration. All right. So let me tell you where we go from here. Since some of these materials have been newly submitted, obviously I haven't had a chance to read them since they just came in at lunchtime. Yeah. So what I'd like to do is take an opportunity to review the case law that has just come in. And Ms. Comrie, I don't know if you have additional case law you want to submit. I can put a time frame on that and give you all a deadline to submit both sides any additional case law you would like for the court to consider. Do you want to do that, Ms. Comrie?
That'd be fine.
Okay, how much time is reasonable?
For me, I'll get this to you no later
I
than
can
8
give
o'clock.
you 5 days, 10 days.
Chagrin's coming today.
Oh, okay, thank you, sir.
You want me to, for clarity, Your Honor, you want me to bring a printed out hard set to your mailbox or Dropbox, or you want, because it's in the court record, so it's going to show up in a couple of days. But if you want me to just, I was going to print them out now and bring them over to you and have them brought over to you.
Okay, yeah, because then I can stamp them and the exhibits that you are been admitted and make sure they get to the clerk's office properly as exhibits. Yeah, so that would be fine, sir. I don't have a problem with that.
Okay.
Just make sure that whatever you submit to the court, that you provide a copy to Ms. Comrie so that she has it as well. And I'll in an abundance of caution, I understand you said you'd get it today, but I'm going to give the parties 5 days to submit additional case law. That would be 5 business days.
Okay.
So let's see here. Today is
It'd be the 25th, 26th.
1, 2, yeah, but it would be 5 business days, sir. So I'm going to exclude Saturday and Sunday.
28th.
2, 3, 4, by the 28th by 5 p.m. Does that give everybody sufficient time?
Absolutely. And for clarity, does Ms. Comrie want me to mail them to her, or is she satisfied with the electronic filing of me submitting it to her electronically? Because I think I've already served her electronically.
Yeah, I received it electronically.
Okay, all right. So if you could provide a copy of whatever additional case law to Ms. that you're going to provide to Ms. Comrie electronically, that's great. And I'd ask her to do the same with any case law she would like submitted as well.
Yes, Your Honor, no problem.
Okay, all right, folks, I'll be on the lookout for your submissions. And at some point, you'll be getting a written order from the court after those submissions come in.
Thank you for your time. God
All
bless.
right. Have a good day, folks. Thank you.
Bye-bye.
Well, that went a little bit differently than I expected, but we got it all on the record. Everybody will be able to see this. For those who got my link, you probably watched it live. For the rest of you all, we can have something to discuss. I will have this video up probably sometime later on today. With that being said, hopefully any comments, good, bad, or indifferent, I'm looking forward to hearing it, and hopefully you all benefited from what just transpired. Everybody out there, take care. And I appreciate you tuning into this video.